of landslide approach at the Dharwad Bridge. And that matter, my lord, is on 18. By virtue of this PIL pending, my lord, Leonard Single Judge expressed since the matter is by
Which PIL?
Can't pass order. Therefore, my lord, we have made an impleading application before this on the report. I have it on Monday. I will make all submission because individual people approach this PIL is not maintainable because all affected party approach.
Which PIL is not maintainable?
This PIL which I am moving now. I am moving this is WP 19544 of 22, which is filed by my lord for public of third person has approached this.
You have filed it.
No, I'm not filing.
But you said you are doing. You are doing the PIL.
No, I'm impleading application. I have filed impleading application, bringing the notice of this court, saying that all individuals.
If you file that
on Monday, since 18th, that is taken for the Dharwad Bridge.
Put it on some
Monday.
Either mentioning through, sir.
Your Lordship's kind appeal has been filed against a Section 9 application has been granted by the learned commercial judge is with respect to lands which are not specifically covered under the MOU which the arbitration. It's a pending matter in which I had taken out service in March itself. I'm requesting that it be listed any date after because I have
March or what was the date?
March. I have taken out service.
Twice.
I'm not aware when it was served in the respondent.
Well, at least
but
what date the matter is fixed. It must be fixed. There must be a date to be fixed. So you don't
I have taken out service on 5th March itself to the respondents.
There must be a returnable date.
Right.
You find out what the returnable date is. You don't have to mention it once you're aware of it.
It's not been listed. Any date.
First, you apprise yourself of the facts. Then you can.
Application of setting aside ex parte degree, my lord. The only submission is the counsel has to travel from Delhi, so I'm kindly requesting to post it on 17th, my lords.
All right, sir.
Much obliged.
List 1, seal number 22.
Petitioners have engaged a senior counsel in this matter. Otherwise, having a little inconvenience to them. And in this, the
2023 matter.
yes, the demand notice amount has already been paid under protest in this case. And an interim order has been passed way back in 2023 itself. But last year, what had happened, my lords, by oversight, I think that interim order was overlooked and they had been stopped from working. So they have lost out about 8 months of that period. In the meanwhile, this matter got, the councils had changed, my lords. So the matter got dismissed for default also, my lords.
In this matter, if you want an adjournment, then it's obvious that you're not interested. Your matter has been dismissed. You move for restoration. Then you move for early hearing. On the date of early hearing, you want an adjournment. Then we adjourn adjournment. You move for early hearing, correct?
Early hearing was filed only after 6 months.
All right. You filed an early hearing.
Then thereafter, my lords, the senior counsel was engaged in this matter.
Early hearing, on the date of early hearing, we are asking you to argue the matter. You have said no arguing in the matter.
We will argue. So only the senior counsel is.
Once again, an adjournment is sought by the learned counsel for the
26 number. Number 23. We have to file objections, my lord. Statement of objections. Next time we'll get it filed.
It wasn't We've given this order, we've given a detailed order on 16 to.
Objections are ready, my lord. I'll get it filed, my lord. Week's time I'll get it.
It just seeks further time to file. The other state no objections. Let the same be filed within the same period. Please stop.
So 19th November. Number 24.
For the petitioner, Your Lordship. Your Lordship had directed the respondents 3 and 4 to file a affidavit with Your Lordship. Clearly stating whether the existing road is a public road or a part of the forest.
That is what you have to file. You just have to tell us what was the nature of the road. Then there's a request further time to. File an affidavit is directed. The order dated 13/7/2026. A request list on.
19th November.
Please.
25 urgent. Still number 26. For non-compliance of office objection third time.
Yeah, appear for petitioner, my lords. I seek for a short accommodation to comply with the office objection.
The third time,
Please, my lords.
what is the office objections? Learned counsel appearing for the petitioner seeks further time to cure the official objection. The final opportunity is granted to the petitioner to do so within a period of 2 weeks from today. Yes.
18 November. 27 is urgent. 28 urgent, a giant request to 23rd November. Final matters.
29, I appear for the appellant.
Yes.
There seems to be in the causeless statement that the paper book has not been filed. In fact, on 21/11, I filed what is titled convenience compilation. That is in fact the paper book.
All right, we'll see it.
Very good.
Proceed with it.
Your Lordship. So 37 appeal. In the arbitral proceedings, I was the respondent.
Who's appearing for the
Mr. Akshay Karpolle.
He has appeared on all prior dates.
Yes.
He has appeared previously in the matter.
None appears for the respondent. In the interest of justice, re-notify.
16th November.
Could I request possibly a shorter date, Your Lordship?
We'll give you a normal date now.
Very well.
Number 30.
And for the appellant in the first matter, my lords. My lords, I pray for a short date, my lords.
What ground?
Seek some more.
My lords, we need some time, my lords.
Request for adjournment is made by the learned counsel for the appellant. Request this.
18th November. Passover matters. List 1, still number 4. Four urgent. List number 1, still number 19.
My lord, I represent the appellant in the matter.
Yes.
My lord, I'm being led by a senior counsel in the matter. And the client strict instructions are that I proceed with the senior.
You can't say that you can please allow.
My lord, if I
Store your
can submit,
petition and then you don't even want to argue the matter.
my lord, if I can submit this, my lord, I'll not press on the recalling application. If it could be taken up on the same stage on Monday or Tuesday with my lord's kind convenience. This is my request, my lord.
If you're not pressing your recalling application, we don't have any reason to put it on Monday or any other day.
My lord,
Because it stands
if
dismissed.
lordships could kindly accommodate me on Monday. Client's written instructions are that I proceed with the senior counsel. Because I've always been led by a senior counsel in the matter.
At the request, learned counsel for this.
May I say something? Admittedly, my lords, they have filed an essay which is pending before the DRT.
We are not passing any order. His petition is dismissed as of date. Stands dismissed. Learned counsel appearing for the applicant submits that he is not pressing the application at this stage and seeks a request for adjournment. Today, it's a request for adjournment. States that he is his instructions to engage with senior counsel. That is request listed.
A date may be fixed.
25th November.
November, my lords. I am an auction purchaser here.
There is no interim order.
Very well.
There is no writ petition. There is no petition.
Very well.
Why? What is your concern of wanting?
No, that's the submission that they make before the DRT, my lord.
There is none. We have recorded it expressly. He's not even pressing his application today. He's asked for adjournment.
Yes.
19 and 20, 25th November. So list 2, seal number 6.
Rest all the-
ಇದೆಲ್ಲ ಬೇಡ ಇದು ಒಂದೇ ಕೊಡಿ 15,490 ಯಾಕಂದ್ರೆ ಎಕ್ಸಾಮ್ ಸಪೋರ್ಟ್ ಇದು ಮಾಡುತ್ತಾ ಚೆಕ್ ಮಾಡಿ ಇದೊಂದು ಕೊಡಿ ಒಂದು 66 ಅಲ್ಲಿ
Hey, please. Yes.
Yesterday, I was taking the court through Justice Nagmohan Das committee report. I'll quickly just show, I'm not going to read it, quickly go through.
Just give us a paras like we said.
Yes, yes, that also I have prepared.
I have to give it to the other side also because they're not present here today.
Yeah, I have given, advance copy is given. So what I wanted to show is various factors which the committee has taken note to make out a case of extraordinary circumstances warranting the enhancement of the reservation. Now, how the globalization, liberalization, and privatization has shrunk the space for reservation, by reason of which the opportunities are dwindling, and therefore it's a very serious matter that is provided under pages 166, 166. That would be 219, 220, and 221. How privatization has seriously jeopardized the reservation policy. In the next chapter, the committee shows how private sector is growing and has taken over the economy of the nation, and where there is no provision whatsoever for the benefit of the scheduled caste, scheduled tribes by way of any affirmative action or reservation. That is private sector. That is seen at pages 224 onwards. Then, last but not the least, is I request the court to kindly permit me to show one paragraph which is of utmost importance.
Yes.
Yes, only one paragraph. I'll trouble the court at page 224.
Yes, we read that. We're reading that only.
Please, oblige. So that is the importance of the private sector, where there is no space for this 90% of the population. Absolutely no space, no opportunities.
Yes.
Then kindly come to page
23.
.281 may kindly be perused.
Yes.
This is how the commission has brought.
You said 281 is 24.10%. Where do you get this figure from?
280,
281, which you said.
yes, 281.
It says the reservation is 24.1%.
Very last sentence.
Clause B.
All these issues,
Yes.
all these issues have been discussed in Ratnapaba committee report, which has gone into the question of reservation in promotion to scheduled castes and scheduled tribes in Karnataka. Government of Karnataka has formulated its policy of reservation for SC/ST communities. Judiciary has accepted the legislation promulgated by the court. Anyway, I'll also be referring to Ratnaprabha committee. I'll not trouble the court further. But this thing, the committee has also shown how in the other states there is an increase in this thing. Of course, I should congratulate this honorable court, because all those courts are still to take up the matters for hearing. We have made substantial progress, and Karnataka has always been the leader in the field of social justice. I hope our judgment will be the trend setter for the whole nation. That I will not trouble the court. Various other states have already enhanced the reservation. It is at various stages of consideration. Then at page 28. Page 280, 281, 228. Yeah. Kindly come to the next page. That will be 283.
Yes.
at the bottom of the page at 283. Why enhancement? The final conclusion the committee has arrived at. The last paragraph may kindly be perused. May I read that paragraph? May I read? To sum up, the basic issues discussed in this part of the report are as follows. The scheduled caste, scheduled tribe communities have not been getting reservation in proportion to their respective population in the total population, shown based on the census data. The Directorate of Economics and Statistics, Government of Karnataka, has published the projected population of the state up to 2020. Based on this, it is shown that the scheduled castes and scheduled tribes have not got representation in proportion to their population in total population. The representation, backwardness, etc. of the scheduled caste, scheduled tribes in the state is discussed in this part. How these communities remain backward in literacy, in education, primary and higher, has also been demonstrated with the help of the data on enrollment and performances in the examinations is analyzed. The representation of scheduled castes and scheduled tribes in government services, public sector has not been equal to the statutory reservation provided by the government. How much gap is between actual representation and statutory level and the extent of shortage has also been calculated and analyzed. The representation of the scheduled castes and scheduled tribes in A and B grades of government service has been lower, while their representation in group C and D has been higher. Based on the data of NSSO about the employment and unemployment, it has been shown that the scheduled caste and scheduled tribe workers are crowded in the informal sector. It has been shown that the scheduled caste, scheduled tribe communities are backward, etc., etc. I will not trouble. Kindly come to the last paragraph. The Supreme Court has been expressing its opinion, judgment after judgment, against using population as the main indicator for providing reservation to scheduled caste and scheduled tribes. It has suggested that in addition to population, backwardness in literacy and education, their overcrowded presence in the informal employment market, their extent of deprivation in income, multidimensional, etc., are to be taken into consideration for determining the communities eligible for reservation. This part of the report, 4 criteria needed to be considered have been identified. In all the 4 criteria, the scheduled caste and scheduled tribe communities in Karnataka are eligible not only for reservation, but also for a hike in the rate of reservation. This is how they conclude and come forward to page 287. The committee notes to last but one paragraph. Consequent to policies of liberalization and globalization, the employment opportunities in the government sector have been shrinking day by day. Lakhs of sanctioned posts have remained unfilled, vacant in the government sector. The disinvestment policies of the government have led to selling of many public sector projects to private corporate houses, and in some cases, they are closed or production has been suspended. Many industries have adopted computerization. Besides, contract outsourced labor systems have been adopted. All these developments have been making social justice irrelevant in our society. Then next page, in the middle, a minuscule section of the scheduled caste and scheduled tribe communities have been able to achieve upward mobility during the last 70 years of Indian Republic, though reservation, through reservation. Apart from this, a huge population belonging to these communities has been continuing to lead a life of distress and destitution. The government has to think about the ways and means to improve. Reservation is necessary. You must remember that the entire SC/ST cannot achieve development only depending on reservation. That is, then untouchability is referred in next page. I will not trouble the court. I have already given the data. Kindly come to page part 10 at page 290. This is the final recommendation of the committee. I've already shown how the committee has come to the conclusion that the estimated population of the scheduled caste is 18% and ST is 7.5%, that is 25. Now the recommendation number 1 is important. Reservation in Karnataka for scheduled caste can be increased from 15 to 17%, and that of scheduled tribes from 3 to 7%. Kindly mark it. 17% as against the 18% population, and 7% as against 7.5. This is not a proportionate reservation, is my very respectful submission. So with these recommendations, the committee has very strongly advocated enhancement of this thing. So I'll give a ready reference. Having said that, since the entire data on which Justice Nagmohan Das has relied upon is what is known as Ratnaprabha Committee report. And the circumstances in which that committee came to be constituted was interesting. Court may kindly recollect, an act had been passed giving consequential seniority to scheduled caste and scheduled tribe employees who got reservation, who got promotion under the reserved quota. Now that came to be struck down, BK Pavitra versus State of Karnataka. It came to be struck down on the sole ground that there is no supporting empirical data. In the circumstances, government constituted a committee known as Ratnaprabha Committee. Sir, with all humility at my command, I should say, fantastic data collection has been done by this committee. I have not come across any other report. Hundreds of cases I have argued. First class information, empirical data. Such a classical exercise has been done by Ratnaprabha. Kindly permit me to show just a few paragraphs which are very relevant. Here also I am giving the I'll confine myself to the main what is adequacy of representation, on which my learned friends have labored so much. How is adequacy of representation dealt with? Now, because this was the object of this committee was to collect empirical data to find out whether consequential seniority should be given to those who are promoted. But the data collected is useful for our purpose as well. Yes. Kindly come to page 22. 22 of volume 1. Historical facts and other things. I will not trouble the court with the other. Atrocities are also dealt with. I will not trouble the court with those things. Educational backwardness is also dealt with. Kindly straight away come to economic backwardness, land holdings, everything is covered. I've given the details. One paragraph at page 21 may kindly be perused. Conclusion at paragraph 1.9, page 21.
Yes.
As explained above, the scheduled caste, scheduled tribes are really facing the problem of social, educational, and economic backwardness even after 70 years of independence. Though the political equality is seen in some quarters, economic and social equality is yet to be seen by the scheduled castes and scheduled tribes. The data unequivocally proves, this is important, data unequivocally proves that the inequality and backwardness is highly prevalent and still persisting among the scheduled castes and scheduled tribes, which demands affirmative action. These facts are well observed in the 12th five-year plan document, and the policy of inclusive growth was adopted to bring the scheduled caste, scheduled tribes to mainstream of development. The government of Karnataka, after recognizing the glaring social and economic disparity in economic development among the scheduled caste, scheduled tribes, has introduced special component plan to ensure that all departments earmark 15 and 3% of their budget for the exclusive development of the programs respectively. The next chapter deals with inadequacy. Sir, page 24, R.K. Sabharwal is referred and followed. Last paragraph, methodology. Before quoting the last sentence, this matter has been agitated in several Supreme Court cases, prominently in R.K. Sabharwal and others. Relevant extracts are there. How posts and vacancies. Then Nagaraj is referred in the next paragraph. At the bottom of the, after culling out the law laid down in those cases, this is what the committee says. In the light of the above observations, it is felt appropriate that analysis of the data should be by taking the total cadre strength. It must be mentioned here that currently the state government provides vacancy-based reservation and not post-based reservation. Further, the government order dated 13/4/1999 stipulates promotion shall only be given to such cadres where the percentage of the representation of scheduled caste and scheduled tribes is below 15 and 3% respectively. This is a mechanism to ensure a cap that the provision of reservation in promotion is not activated in cadres where there is adequacy of representation. So this is a very, very important self-correcting mechanism pursuant to the decision of the Sabharwal. A government order was issued saying that there shall be no reservation in promotion in government orders. Court copy. I'm placing that government order itself. This is a crucial information because so much is said. You did not go to the cadre, you did not go to each department. The simple mechanism adopted is wherever they have already reached 15 and 3%, promotions are not given on the basis of reservation. Now, this is the order dated 13/4/1999. Since then, only departments where there is not enough representation, reservation in promotion is given. Then the next page, department-wise total strength, total sanctioned strength and the representation as obtained contemporaneously in the year 2016 when the committee went into this exercise is tabulated. Kindly come to para 2.1 at page 27. Sir, I will not trouble the court with all the 31 departments. Just kindly come to the last but 5 columns.
Yes.
Total strength, sanctioned strength is taken. The number of posts filled up by scheduled caste is taken, and then the shortfall in representation is noticed. That is percentage of TSP. And the next one is difference. What is the shortfall? That is made note of. So every department has shown. Kindly come to the bottom of this thing. For the scheduled caste, there is a shortfall of 4.35%. Kindly mark it. This is not with reference to 18%. This is with reference to 15%. Even then, even when taking 15%, which was the quota fixed, it is 4.35. Likewise, come to the last part, one paragraph. Last part one is the representation given 2.92. What is the shortfall? According to the 3% of the quota, out of 3%, there is a shortfall of 0.08%. So it is still less than 3%, though population has shot up to 7.5%. This is as of 2016. And a very interesting graph is given in the next page, figure 2.1. An excellent presentation of the data of all the departments as it obtained in 2016. Then kindly come to the next page. What the committee has done is, instead of going into the nitty-gritties of each department, it has taken 6 major departments where the bulk of the employment is seen, namely education, home, health, revenue, judicial, finance, and these are the 6 departments. And it is tabulated in table 2.2. The representation of the scheduled caste to the total sanctioned posts is seen at 11.30%, while it is 3.14% for the scheduled tribes, scheduled castes and scheduled tribes. Now, a figure is also given contrasting the data. Then there is a collection of huge data for about 30 years, from 1984 to 2016. Entire data has been collated. This is done group-wise. Group A, that is 2.4.1, cadre-wise analysis of the data. And the shortage found for scheduled caste, as could be seen from the last sentence, is 12.07%. And the shortfall is 2.93 compared to 15% quota. Likewise, for scheduled tribes, (2.7) last sentence. Average across 31 years is taken. Representation of STs in cadre A is found to be 2.7, indicating that there is inadequacy of representation in the civil service. Now the same data is tabulated year-wise in the next page. A graph is also given, x coordinates, y coordinates. Ultimately, it comes down to in group A, it is 10.87 the last year, 2016, 10.87 for scheduled castes and 2.94 for scheduled tribes, as could be seen from the graph. Easily can be noticed. Then we come to group B, a similar exercise is done. Excellent data is produced. And the shortfall is also brought out on record. The shortfall for group A for scheduled caste is 2.69, and for scheduled tribes, it is marginally above 3%, namely 0.08%. This is again plotted on a graph. Next page, figure 2.4. Similar exercise is done for group C from page 38 onwards. Kindly come to the summary straight away at page 44. Yes. Particularly applicable. Page 44. Yes. I just read the analysis of time series data collected for the last 32 years, except for 1986, across 31 departments of the State Department provides the rich information on the inadequacy of representation of scheduled caste and scheduled tribe employees in various cadres of Karnataka civil services. The total number of sanctioned posts as per the data of 2016 is 7,45,593, of which 70.22% or 5,23,574 are filled up across 31 departments. The vacancies or posts are filled up through direct recruitment and promotions, including consequential promotion, consequential seniority, consequential promotion. The overall representation of scheduled caste and scheduled tribe employees of all 31 departments in comparison with the total sanctioned posts comprised 10.65% and 2.92% respectively. This proves inadequacy of representation of the scheduled caste and scheduled tribes. On an average, the representation in cadre A for scheduled caste is 12.07% and for scheduled tribes is 2.7%, which sufficiently proves the inadequacy of representation. The extent of representation in group B is, on an average, 9.79% and 2.34% for scheduled tribes for all the years of the study period. Pausing for a minute, I kindly permit me to say this. Adequacy of representation should not only be numerical, but should also be qualitative. Meaning thereby, it should not only be in the lower ranks of group D or group C, it should also be there in the higher posts where decisions are made, policies are made, judgments are given. That is where. So it is highly important. Group A and B play a very predominant role in deciding the adequacy of representation. And I very respectfully submit that Indrasani has said this, and right from Rangachari, this has been In fact, that's the reason why reservation promotion was upheld in Raghav. That reservation should not only be numerical, adequacy should not only be numerical, but it should also be qualitative. So that being the position, group A and B are sufficient to clink the issue that there is underrepresentation, that they are inadequate in their representation in the service. Be that as it may, kindly permit me to show the next observations of the committee. Para 7. It is observed that on an average, 3.05% of scheduled caste representation is inadequate in Group C, whereas 0.05% is excess representation as seen for the scheduled tribes. Sir, kindly mark it. This is not with reference to their population. This is with reference to the quota of 15 and 3 fixed, which is itself an undervaluation of the adequacy. Be that as it may, they take that as the standard to say either underrepresented or overrepresented. Para 8. On an average, 2% and 1% overrepresentation of employees of scheduled castes and scheduled tribes is found in Group D, respectively. However, in the last 5 years, inadequacy of representation of scheduled castes by 3% is found in this cadre. Elsewhere, the committee has very graphically recorded why there is predominance of the scheduled castes and scheduled tribes, because these are all menial jobs. These are all jobs of inferior variety. And much of these jobs are unskilled jobs, where the upper caste don't volunteer, they don't come. So therefore, there appears to be some overrepresentation of scheduled caste and scheduled tribes in these cadres, that is Group D cadres. Then para 9, the representation of scheduled castes in Group A, B, and C is on an average 12, 9.79, and 12.04% respectively, whereas in cadre D, it is 16.91. In case of scheduled castes, the cadre A and B representation is 2.7 and 2.34%. However, excess representation of 0.04 and 0.93 is found in case of Group C and D. Over-representation in some years, departments is attributed either to direct recruitment or retirement of employees, or, this is important, filling up of the backlog vacancies as the later does not, it does not fall under the 50% cap because of Article 16(4)(b). But may kindly recollect, Karnataka has made very considerate. 27(4)(78), it introduced reservation in promotions to see that the qualitative representation is improved. Then most of the posts were going unfilled, so it amended the general recruitment rules and provided for filling up the backlog also. That is the subject matter of Bhakta Ramegowda's case in the Supreme Court, which upheld this provision. Later, even in direct recruitment, unfilled vacancies, there was a special drive 2001, special rules for them. Like this, the backlog posts have come, and to some extent, Group C and D seems to be a bit more than the quota of 15 and 3. For this reason, namely, backlog posts have been filled up. That is what the committee has. So the concluding remarks, para 2.6, the data clearly shows the inadequacy of representation of the scheduled castes and scheduled tribes in the civil services in Group A, B, and C, and adequate representation in Group D. Then the committee deals with the administrative efficiency of administration. I'll come to it later. Before I go to the efficiency of administration, on which also much has been said, I want to show that this report of Ratnaprabha is not only time tested, but it has stood the test of judicial scrutiny. Kindly permit me to show from BK Pavitra, 2019, volume 16, SCC, page 129. My learned friends have placed it before the court. Volume 2. Sir, the very argument which has been advanced here was advanced before the Honorable Supreme Court, criticizing the report as not cadre-based. Para 46 at page 751. The contention of the petitioners is noticed. Then kindly come to para 56. That is answering the allegation that legislature has overruled BK Pavitra 1. That is answered. In particular, I would request the court to kindly permit me to show at page 759, para 56.8. 56.8. The heading of this section is B. Ratnaprabha Committee has dealt with all the three facets constituting the compelling reasons. 56.8 deals with backwardness. The decision in journal has clarified that there is no requirement of collecting quantifiable data on backwardness of scheduled castes and scheduled tribes. The observation in Nagaraj is contrary to larger bench decision in Indrasani. Yet, in any event, Ratnaprabha Committee considered the backwardness of scheduled castes and scheduled tribes in view of the dictum in Nagaraj, which then held the field. The committee, after carrying out the exercise, came to the conclusion that the requirement of backwardness is satisfied. On the inadequacy, next para, on the inadequacy, 56.10, Ratnaprabha Committee report considered the inadequacy of representation. I will not trouble the court, I have already read the. Kindly come to 56.16. Next page, 56.16. On promotion, a candidate is required to serve a statutory period of officiation before being confirmed in service. This applies to all candidates, including the roster point promotees, and ensure that efficiency of administration is not adversely affected. Then come to the paragraph at 92. Ratnaprabha Committee report E2 at 788. para 92. The decision in BK Pavitra was rendered on 9/2/2017. Ratnaprabha Committee was established on 22/3/2017. Its report was examined by a cabinet subcommittee on 4/8/2017. Was eventually approved by the cabinet on 7/8/2017. Ratnaprabha Committee report was commissioned to 1. Collect information on cadre-wise representation of scheduled caste and scheduled tribe employees in all government departments. 2. Collect information on backwardness of scheduled castes and scheduled tribes. 3. Study the effect of administration due to the promotion of scheduled castes and scheduled tribes. Now, Dr. Dhawan's contentions are noticed. Kindly, next para, kindly see the item number 6, is contention number 6, is the same as what my learned friend has advanced against the statute here. The data is based on grades A, B, C, and D, and not cadre based. Now, this was the ground on which it was challenged. Kindly come to para 96, a very crucial paragraph, which applies on all fours to the present statute as well. Para 96 at page 789. I read that. Clause 4 of Article 16 contains an enabling provision to empower the state to make reservations in appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, is not adequately represented in the services under the state. Clause 4A contains an enabling provision that allows the state to provide for reservations in promotions with consequential seniority in posts or classes or posts in services under the state in favor of scheduled castes and scheduled tribes. Clause 4A also uses the expression, which in the opinion of the state are not adequately represented in the services under the state. It is in pari materia with clause 4. Clause 4 and 4A, not adequately represented in the services under the state. In Indrasani, while construing the nature of the satisfaction which has to be arrived at by the state, the court held, quote, para 798, the language of clause 4 makes it clear that the question whether a backward class of citizens is not adequately represented in the services under the state is a matter within the subjective satisfaction of the state. Kindly mark it. It is a matter within the subjective satisfaction of the state. This is evident from the fact that the said requirement is preceded by the words, in the opinion of the state. This opinion can be formed by the state on its own, that is, on the basis of material it has in its possession already, or it may gather such material through a commission or committee, person or authority. All that is required, kindly mark it, sir, this is very important. All that is required is there must be some material upon which the opinion is formed. There must be some material upon which the opinion is formed. Indeed, in this matter, the court should show due deference to the opinion of the state, which in the present context means the executive. The executive is supposed to know the existing conditions in the society, drawn as it is from amongst the representatives of the people in parliament and legislature. It does not, however, mean that the opinion formed is beyond judicial scrutiny altogether. The scope and reach of judicial scrutiny in matters within subjective satisfaction of the executive are well and extensively stated in Barium Chemical Sources Company Law Board, which need not be repeated here. Suffice it to mention that the said principles apply equally in the case of a constitutional provision, like Article 16(4), which expressly places the particular fact of inadequate representation within the subjective judgment of the state or the executive. My very respectful submission is this applies with greater emphasis to a legislation. Even the executive was given this privilege. The above extract from the decision in Indrasani presents two mutually complementary and reinforcing principles. The first principle is that the executive arm of the state is aware of the prevailing conditions. The legislature represents the collective will of the people through their elected representatives. The presumption of constitutionality of law, kindly mark it, sir. The presumption of constitutionality of law enacted by a competent legislature traces itself to the fundamental doctrine of constitutional jurisprudence that the legislature is accountable to those who elect their representatives. Collectively, the executive and the legislature are entrusted with the constitutional duty to protect social welfare. This court explained in Amalgamated Tea Estates versus State of Kerala the rationale for the principles of constitutionality. Quote, the reason why a statute is presumed to be constitutional is that the legislature is the best judge of the local conditions and circumstances and special needs of various classes of persons. The legislature is the best judge of the needs of particular classes and to estimate the degree of evil as to adjust its legislation according to the exigency found to exist. The principle was reiterated in V.C. Shukla versus State. Quote, furthermore, the legislature, which is in the best position to understand the needs and requirements of the people, must be given sufficient latitude for making selection or differentiation, and so long as such a selection is not arbitrary and has a rational basis having regard to the object of the Act, Article 14 would not be attracted. That is why this court has laid down that presumption is always in favor of the constitutionality of an enactment, and the onus lies, this is important, sir, the onus lies upon the person who attacks the statute to show that there has been an infraction of the constitutional concept of equality. Unquote. Just pause for a minute, sir. I've given such an overwhelming data to show that the statute is based on such an empirical data, contemporaneous data, compelling circumstances, making out an extraordinary. Not an iota of data is produced. How are they discharging their burden? It should be, all the petitions should be thrown out on that short ground. Not an iota of data to counter. They have not doubted any finding of the committee, Ratnaprabha committee, or Nagmohan Das committee. Not a single statement doubting the correctness of this data or that data, or this representation or that underrepresentation. So that is very important. I therefore emphasize this. The onus lies upon the person who attacks the statute to show that there has been an infraction of the constitutional concept. Para 97. More recently, this was emphasized in State of Health, HP versus Satpal Saini. Quote, the duty to formulate policies is entrusted to the executive, whose accountability is to the legislature and through it to the people. The peril of adopting an incorrect policy lies in democratic accountability to the people. Unquote. The second of the reinforcing principles which emerges from Indrasani is that the opinion of the government on the adequacy of representation of scheduled castes and scheduled tribes in the public services of the state is a matter which forms a part of the subjective satisfaction of the state. Significantly, the extract from Indrasani reproduced earlier adverse to the decision chemicals, which emphasizes that when an authority is vested with power to form an opinion, it is not open to the court to substitute its own opinion for that of the authority, nor can the opinion of the authority be challenged on grounds of propriety or sufficiency? Kindly mark it. Propriety or sufficiency, it is not their cup of tea to say the data collected is insufficient or that it is improper. In Nagraj, while dealing with the parameters of governing the assessment of adequacy of representation or of the impact of efficiency, the Constitutional Bench held, quote, the basic presumption, however, remains that it is the state who is in the best position to define and measure merit in whatever ways it considers it to be relevant to public employment, because ultimately it has to bear the costs arising from errors in defining and measuring merit. Similarly, the concept of extent of reservation is not an absolute concept, and like merit, it is context specific. Reservation is necessary for transcending caste and not for perpetuating. Reservation has to be used in a limited sense, otherwise it will perpetuate casteism in the country. Reservation is underwritten by a special justification. Equality in Article 16.1 is individual specific, whereas reservation under 16.4 and Article 16.4a is enabling. The discretion of the state is, however, subject to the existence of backwardness, inadequacy of representation in public employment. Backwardness has to be based on the objective factors, whereas inadequacy has to factually exist. This is where judicial review comes in. However, whether reservation in a given case is desirable or not as a policy is not for us to decide, as long as the parameters mentioned in 16.4 and 16.4a are maintained. I repeat, this is where, however, whether reservation in a given case is desirable or not as a policy is not for us to decide, as long as the parameters mentioned in 16.4 and 16.4a are maintained. As stated above, equity, justice, and merit, efficiency are variables. Kindly mark it, sir. They are variables which can only be identified and measured by the state. Can only be identified and measured by the state. Equity, justice, and efficiency are variable factors. These factors are context specific. So what is the context? So much material is thrown both by Ratnaprabha committee and this voluminous material, existence of such voluminous data to support these three factors. That equity, justice, and efficiency are variable factors. These factors are context specific. There is no fixed yardstick to identify and measure these three factors. It will depend on the facts and circumstances of each case. Kindly mark it, sir. This is very, very emphatic statement. It depends on the facts and circumstances of each case, and ours is a special case which warrants enhancement of the quota. Now, having shown this, kindly come to para 100, the next page. Running page 792,
Yes.
last but one paragraph.
Yes.
In dealing with the submissions of the petitioners on this aspect, it is relevant for this court to recognize the circumspection with which judicial power must be exercised on matters which pertain to propriety and sufficiency in the context of scrutinizing the underlying collection of data by the state on the adequacy of representation and impact on efficiency. The court is above all considering the validity of a law which was enacted by the state legislature for enforcing the substantive right to equality for the scheduled castes and scheduled tribes. Judicial review must hence traverse conventional categories by determining as to whether Ratnaprabha committee report considered the material which was irrelevant or extraneous, or had drawn a conclusion which no reasonable body of persons could have adopted. I repeat, conventional categories by determining as to whether Ratnaprabha committee report considered material which was irrelevant, extraneous, or had drawn a conclusion which no reasonable body of persons could have adopted. In this area, the fact that an alternate line of approach was possible or may even appear to be desirable cannot furnish a foundation for the assumption of the court of a decision-making authority, which in the legislative sphere is entrusted to the legislating body and the administrative sphere to the executive arm of the government. Sir, kindly pause for a minute. What is the case made out? Is it their case that these two reports are irrelevant, or the data collected is irrelevant, or that they are extraneous? What is the case made out? I don't see. What is the merit in these petitions? Because the burden is on them. All right. So, on all fours, this statement of law at paragraph 100 is more than adequate to throw out these petitions, lock, stock, and barrel. Kindly come to para 101.
We've seen this.
Yeah, the summary is set out. Then one very important statement is 103 on the methodology.
Read this.
Sir, sampling is a well-known concept of survey. You need not survey the entire population. You can take a sample and test. In Kannada, they say to test whether the rice is ripe for eating, you take one grain and test it, that is sufficient.
Yes.
Like that, you take a sample, and the accepted sociologist this thing, because I have also done this, 1% of the population is enough for a sample survey. As against that, what the committee has done, kindly permit me to show at paragraph 103.
We've read this,
Yeah.
Mr. Verma.
Sampling,
We've read this.
quantitative, qualitative, both are
We've read
emphasized.
this.
Then 104 may kindly be seen.
So, we've read this judgment. You
Obliged. Obliged.
read it word by word.
I'm grateful to you. 106, sir. Formation of the opinion, 106. Then 107 on the adequacy of representation. 109 on the presumption about the data. There is a presumption about the data that is collected, that it is correct, valid. That is 109. 110, again Indrasani is referred, and the report is held to be Indrasani and Sabarwal compliant. Then, last but not the least, is 152, very important statement.
Yes.
152. Now, because one of the allegations is Ratnaprabha collected only group, not the specific cadres. There may be 2 or 3 cadres in each group. It is not cadre specific. That was the allegation. Now that is addressed. That is how the Honorable Supreme Court has approved Ratnaprabha. Kindly come to page 152. Para 152 at page 819. Over-representation in KPTCL and PWD. Ratnaprabha committee collected the data from 31 departments of the state government. It's been pointed out on behalf of the state that corporations such as KPTCL and other public sector undertakings fall within the administrative control of one department of the government. The position in 31 departments was taken as a representative of the position in public employment under the state. Over-representation in KPTCL or PWD has been projected by the petitioners with reference to the total number of posts which have been filled. On the other hand, the quota is fixed and the roster applies as regards the total sanctioned posts as held in Sabarwal and Nagraj. On the contrary, the data submitted by the state of Karnataka indicates that if consequential seniority is not allowed, there would be underrepresentation of the reserved categories. Finally, it may also be noted that under the government order dated 13/4/1999, which I have just now drawn the attention, under order dated 13/4/1999, reservation in promotion in favor of scheduled caste, scheduled tribes has been provided until the representation of those categories reach 15% and 3% respectively. After that, it stops. Where is the question of any over-representation? The state has informed the court that the above government order is applicable to KPTCL and PWS. For these reasons, they endorse the big Ratna Prabha. So, it is my very respectful submission. Ratna Prabha report is time-tested and judicially tested. Nagmohan Das is only an upgradation of that and updating of the data. So it also needs to be endorsed at the hands of this honorable court is my very respectful submission. Having said this, a lot of statements were made about the efficiency of administration. I'll just briefly touch upon that and rest my case so far as that. Efficiency of administration is one aspect.
Also has been dealt with in the same judgment.
I brought on to that. Yes, it has been. More importantly, Ratna Prabha has considered so many aspects, not only the merit, that all the employees are judged by the same standard. They have to pass the same efficiency bar, and they have to earn the annual confidential remarks on the basis of their performance every year. That is not different or reduced standard for scheduled castes and scheduled tribes. And more importantly, which the committee has not said, I'm saying it by my experience. Sir, anybody who earns bad remarks will be weeded out as deadwood under Rule 285 Note 1. Compulsory retirement. How many district judges are sent home by this honorable court on the ground that they are deadwood? So, efficiency of administration is fully taken care of. More importantly, Ratna Prabha committee has highlighted the achievements of the state with 140 years of reservation, how it has marched ahead of all other states in the country. I rest my case by saying that, except one aspect. Why do they say there is impairment of the efficiency? On what basis they say? Are the scheduled castes and scheduled tribes untouchables for state service? How does it suffer just because they come under a prescribed quota? My very respectful submission is this is a false assertion on the part of the petitioners, repeatedly made without any foundation, without any basis, and without any committee finding that the scheduled castes are in any way incompetent, inefficient, or they have contributed to the miseries of a state administration. Most unfounded, uncharitable allegation is that efficiency is impaired by providing reservation. On the contrary, I am really very happy to Sir, Mr. Veerappa Moily was the Union Minister for Law. Incidentally, he happened to be my colleague. We come from the same chambers. He was commissioned as an oversight committee before the 93rd Amendment to the Constitution, providing reservation under Article 15(5) in favor of the socially and educationally backward classes and the scheduled caste in institutions of Central Institutions of Education, CIE. While doing that, a committee was appointed under his chairmanship, known as the Oversight Committee. That committee has made a case study of several states. I'll not trouble the court with all this thing. Only one state, Karnataka. What is the finding of the committee? it has examined whether any lowering of the standard in education would take place by providing reservation. That is a very, very important study which has not been, of course, I had placed it in Ashok Kumar Thakur's case before the Honorable Supreme Court, page 422.
Should have given us soft copies of this instead of
Soft copies
so much
also.
of,
Soft
so
copies.
much of, no, now that you already printed it.
No,
You could have
soft
saved-
copies also I'll give. No, I wanted to ensure that the entire text is given to my learned friends so that they may not have heard of this report. Sir, the report, the relevant case study starts at page 422 of volume 2. Volume 2. I will not trouble the court with the report in its major part. Straight away come to page 425. 425. This is a case study relating to Karnataka. In particular, the Visvesvaraya Technological University, VTU. Para 3.1.1, performance of the OBC students vis-a-vis the general category students. Performance of the OBC students vis-a-vis general category students is indicated in the following table. The performance is measured by the number of students who graduated as a percentage of students who took the examination. Kindly come to the next part, table 2. Sir, column number 3, percentage of pass is given for the general category who are admitted on the basis of merit. Their percentage of pass is 66.09%. As against this, the students admitted under the OBC quota, 32%. Sir, look at their performance. 93% for the year 98, 2002. Next batch, 98.2. Next batch, 97.00. Next batch, 97.0. Head and shoulder above the students admitted under the so-called merit quota. All this is to show that there will be no impairment of merit or efficiency in any way if an opportunity is given to the either to denied sections to have access to education and employment. Kindly come to the note at the bottom of that table. The percentage of students from OBC category passing the examination has been increasing from 93 from 1998-2002 to 97.4 batch of 2001 to 2005. The performance has been consistently better than the performance of the general category students. Kindly come to the table at table 3. More graphic details are given. Percentage of students passing with distinction, while the general candidates passed with 34.22 in the 1998 batch, the percentage of first class with distinction among the OBC candidates was 42.38. First classes, while it was 29 for general candidates, it was 41.59% for the OBC students. Like that, it has discovered, it has shown, demonstrated that given an opportunity, the backward classes, I don't claim any superiority by virtue of this. I only say there will be no impairment. And while this is the proven fact, all kinds of allegations are made that efficiency of administration. One more report I would like to place before the court. This is as old as 100 years. Sir Leslie Miller, who was then the Chief Justice of the Madras, of the Mysore High Court, was tasked to deal with question as to what is adequate representation. Sir, para 6 at page 2 may kindly be perused. I will not trouble the court with the rest of that paragraph. Only one sentence at the bottom of it. We recognize that representation of the Brahmin community in the public services. We recognize that the population is not the only factor to be taken into consideration, and that one important factor is maintenance of efficiency of the services. However, kindly mark this. Efficiency, however, let us see the page 2, para 6. Yes. Bottom of the page, the page number is. So efficiency, however, is not to be measured solely or even mainly by academic qualifications. It will not be denied that there are many important branches of administration in which the other qualities such as sympathy, honesty of purpose, energy, and common sense go as far to make an efficient officer as literary superiority. We do not wish to suggest the Brahmin community is deficient in these qualities, but it cannot and does not claim a greater share of them than the other communities, while its superiority at present in the capacity to obtain academic distinctions can hardly be questioned. So there are various factors. It is not securing marks in an examination, like courage, honesty, integrity. These are the factors. For over 100 years, this has been the rule in Karnataka, as demonstrated by Ratnaprabha report. I therefore very strongly object to the allegation that there is impairment of the efficiency of administration. Sir, one last submission is the Honorable Supreme Court was seized of a matter from Karnataka where 73% reservation had been provided by a legislation passed in 1993. That was the subject matter. And the court called for the empirical data to substantiate how you are giving 73%. Unfortunately, state did not give the data. As a result of it, we are condemned to 50% again. Kindly come to the judgment that was S.V. Joshi. ಎರಡೇ page. There were a batch of cases in fact, that matter was never heard. I was appearing in the matter because we were unable to provide the data that had been called for. What is the empirical data to say 73% population is backward? That day we did not have. Today we have enough data. Ilva? May I give the citation?
Yes.
2012, 7 SCC, page 41. Sir, there were a batch of cases one relating to 69% for Tamil Nadu, another relating to 73% for Karnataka. Kindly come to the last page. I will not trouble the court with
You read this?
Yeah, last page.
You read this?
Data was
It's
called
fully
for.
marked, Judge.
Yes. He read the, yes. So S.V. Joshi had called for it. With these submissions, I am extremely grateful to the court for having given me this opportunity. Judgments on judicial review, I'm just placing them. I'm extremely thankful to the court for giving me the opportunity to present the case. That's awesome. So with these submissions, they have not discharged their burden. No case is made out. No data is put. Only one statement. They have now produced in one of the this thing a statement saying that there is over-representation. May just
They said beginning only they showed the
yes,
data
yes,
from the.
yes. May just address that issue.
Yes.
They have the 2025 data. Number one, this is the data of the year 2025, which does not relate to the period when the act was passed. It was passed way back in the year 2022. So this is not the data that prevailed. Number two, what they have done is they have taken only the filled up posts as distinguished from the total sanctioned posts, which R.K. Sabharwal said that is the yardstick for deciding whether they have been. No. So on either way, this is not acceptable, is my very respectful. In one case, only one case, it's a very unrighteous litigation. He claims to be a scheduled caste. He questions reservation.
Perfectly valid.
No, this can't be public interest. With great respect, how can he maintain a petition against his own community?
It is not, may not be against the community.
It is. And he has been a chronic litigant before the court, number of cases. That petition.
Principally, a reservation can have both sides.
Please.
I'm on 6.4 minutes. 6.4 and 6.2 arise out of minutes an order passed by the Karnataka State Administrative Tribunal. But what they've done, there was 2004, 24 minutes, Karnataka Public Service Commission issued a notification for recruitment minutes to the post of gazetted probationers. That was on the basis of the roster points minutes at 56% reservation. The government order prescribing the additional roster points is challenged. The act is not challenged. And the notification is challenged. The tribunal minutes does not go into the 50%, 56%, the breach of 50% reservation per se, though there is reference minutes to Indrasani and Jayashree minutes in one paragraph. But what the court says is that initially we had issued an ordinance. Under the ordinance minutes, we had issued a government order. Thereafter, minutes act was brought into force with retrospective effect from the date the ordinance was in force, with the savings clause that everything done under the act is saved and everything done under the ordinance is saved. No, minutes. So therefore, the government order continued to hold force. What the tribunal says is, once the ordinance lapsed, your government order lapsed, the savings clause is not noticed. So therefore, government order is quashed. Only prescribing additional roster points, notification is quashed. Now, minutes, we have there 50. The principle, there is a reference minutes to Indrasani and breach of 50%, but that has not been adjudicated per se. If I could take my notes to that petition minutes for a moment. But 6.2 is the state writ petition challenging that where sir is appearing.
How will it survive?
Let's see. The problem was this: the notification was quashed. We came before this honorable court. This honorable court permitted us to go ahead with the recruitment process. It was a 3-tier recruitment process notes where we have a preliminary examination, main examination, personality test, but not to publish the results. Now, when application, personality test is over, the select list is ready, we have to publish the select list. This notification is part of the same notification notes where my lords had permitted by virtue of a generic interim order in the first of the cases to go ahead, my lords, in terms of the 56% reservation, but appointments will be subject to the result of the writ petition. But here, because of the quashing of the notification, there was a separate order that was passed, and that order continues to be enforced. Technically, this it has to be allowed. The writ petitions have to be allowed, and insofar as 56%, whatever follows,
whatever view my lords will be taking, my lords, insofar as the act is concerned, it will apply to all the recruitments. But this quashing of the notification, my lords, has to go, is my respectful submission. I'll take my lords, note 6.2 is a state writ petition where sir is appearing, but the same order is under challenge in 6.4. My lords may take 6.2, my lords, because I had marked the page numbers in that. 6.4 is a Public Service Commission's petition, challenging the same.
6.2, I appear for the state, for the petitioner.
Let's make kindly see page 188 minutes.
Yes.
Plus 188 minutes was the ordinance that was issued. If my lords may see minutes, this was the ordinance that was published on 23rd of October 2022. It contains the same object and reasons, my lords, and it provided for 56% reservation. Now, my lords, page number 163 is a government order which prescribes additional roster points for the purpose of implementation of 56% reservation. 163.
Yes.
Let's at 164 is the operative portion. I'll just read it, minutes. Para 4 minutes before the operative portion. In view of the circumstances explained above, it has become necessary to modify the provisions laid down in Annexure 1 to the Government Order dated 26/1995 above, according to the following order. 95 order, minutes, is a 50% roster point. Under the circumstances explained in the proposal, the 100 points roster in Annexure 1 of the Government Order dated 26/1995 is replaced by revised roster attached to this order, identifying posts to the vacant post in direct recruitment proportional to the enhanced reservation specified for the scheduled caste and scheduled tribes in recruitment, provided in ordinance dated 23/10/2022. There shall be no changes in the Government Order dated 26/1995. This order shall come into force with immediate effect. However, if the process of direct recruitment is already started for any post of the cadre and the recruitment is pending as on the date of this order, such recruitment process shall be completed following the procedures specified in Annexure 1 of the Government Order dated 26/1995. Now, kindly see the Act minutes, page 151. Notes, it starts at 151. Notes may see 154.
Yes.
Let's section 1(2) minutes. It shall be deemed to have come into force with effect from 1st day of November 2022. It was given retrospective effect with effect from the date of the ordinance. Then section 8 may kindly be seen. 156. The Karnataka Scheduled Caste and Scheduled Tribes reservation of seats in educational institutions of appointments or posts in the service under the State Ordinance 2022 is hereby repealed. Notwithstanding such repeal, anything done or any action taken under the said ordinance shall be deemed to have been done or taken under this act. Now, let's kindly see the reasoning minutes of the tribunal. If my lords may see impugn orders at page 35, first at page 36, my lords, their prayer at page 36.
Yes.
Just above the order, my lords, the first line, the application is filed under section 19, my lords, get it, my lords, the first line, the first paragraph. This application is filed under section 19 of the Administrative Tribunals Act, praying this tribunal to quash the government order dated 28/12/2022, issued by the second respondent, and the order dated 26/2/2024, issued by the third respondent. That is a notification, roster point notification, and the recruitment notification of 26/2/2024, Annexure A1. Lords, please see the reasoning, Lords. Page 67.
Yes.
No, page 67, para 13, middle of the page. Before going to the merits of the other issues and claims and counterclaims, it's pertinent to examine the factual position of the date of various notification, particularly ordinance, government order, and the Act of 2022, and so also the notification calling for applications by the respondent number 3. Then, my lords, they have extracted in seriatim, my lords, what has happened from in paragraph number 14 with regard to whatever I just now read, my lords. Then kindly see page 70. just after the quotes is over, page 70. My lords, in view of the
Yes.
In view of the above chronology and the government order, it is clear that the government notification dated 28/12/2022 notifying the roster points is based on the ordinance notified on 23/10/2022. Subsequent to the enactment of the Act of 2022 by the Karnataka legislature and its notification dated 12/1/2023, no rules or no notification has been issued by the government. As learned government Peter has not produced any such notification in his reply statement, he clearly states that the said government notification of 28/12/2022 is incidental to the Karnataka Scheduled Caste and Scheduled Tribes Reservation of Seats in Educational Institutions and of Appointments or Posts to the Service Act 2022. Then, my lords, para 15, they have extracted those below after that, my lords. When rules are made based on ordinance or a government notification is issued based on ordinance, their validity is tied to the lifespan of the ordinance unless it is specifically stated that the government notification remains valid even after the expiry of the ordinance, the savings clause. In the instant case, there is no such provision in the government order dated 28/12/2022, which is passed as a consequence of the ordinance dated 23/10/2022. The contention of the line of government pleader that the government order dated 28/12/2022 is incidental to the Act number 1 of 23 cannot be accepted, since the said government order specifically states that consequent to the ordinance, the government has decided to issue the said notification. Then, my lords, they refer to certain definitions. After that, my lords, bottom of the page in page 72. Except the similarity statement of objection reasons in both ordinance and the Act of 2022, there is nothing to show that the said notification is drawing its strength from Act 1 of 2023, as the ordinance passed on 23/10/2022 has already expired, consequent to Act 1 of 2023. Then, my lords, the next page, page 74. It's in the middle of the page, minutes. It starts with the sentence, though the importance of enhancing the percentage of reservation for SC and ST categories by government has been reflected in the Act 1 of 2023, but there is no order which draws its strength from the Act 1 of 2023. The said notification is only an executive order, and therefore, in view of the ratio laid down by the Honorable Apex Court in the judgment cited by the learned counsel for the applicant Supra, and particularly Indira Sahani versus Union of India case, which states that the reservation provided on the basis of caste, but the state cannot exceed 50% of the said GO. The said GO has no legs to stand. It has been reiterated in Jayashree Lakshmanrao Patil versus State of Maharashtra, and this ratio remains the law of the land. Therefore, we are of the considered opinion that the government notification dated 28/12/2022 is only an executive order without drawing its strength from any legislation, and it's contrary to the ratio laid down by the Honorable Apex Court. In view of the discussion, we are of the considered opinion that the notification dated 26/2/2024, which provides for reservation for posts for different categories to the extent of 56% of the total post, is against the ruling of the Apex Court. Since the government order dated 28/12/2022, based on which the notification dated so and so is issued with third respondent does not survive, the test of it being invoked, we do not find it appropriate to go into other issues and grounds urged by both sides. Now, operative portion notes is at page 77.
Yes.
Application is allowed. Notification bearing number so and so, recruitment notification issued by the third respondent KPSC under heading so and so from internal page 28 to 41, given classification of vacancies tabular form for the reservation to the extent of 56% is concerned set aside. The government order bearing number so and so issued by the second respondent set aside. But this order has to go for this reason. Act is not in question. We had raised that contention. When you have not challenged the Act, you could not have challenged the government order. Government order, there is a savings clause. So the notification was on the basis of a roster points. So now, in view of this order, the notification is under a cloud because there was an interim order.
In any case, now we are hearing the main matter.
I will put it this way. These two petitions, insofar as 6.2 and 6.4 megawatts.
If you were to reject the PIL, then of course your issue would arise. But if you were to accept the PIL, then
even if my lords accept the PIL, my lords,
then your Act will go.
No, the Act will go, my lords. The Act will
your
go.
own case said your notification is under the Act.
It's under the Act.
How will that survive?
Please, my lords. It is in respect of already issued notifications, which is covered by the interim order, which is subject to.
That interim order automatically will now fructify if, for example, the PIL is allowed.
Please.
And the Act is struck down. What is the fate of your petition?
Even this notification also will be subsumed by that, my lords.
Then the petition will automatically, without anything, be dismissed.
Please. then
observation that this is now an academic exercise. What you
academic,
want is
my lords have to say that. Otherwise, but if it is,
let's finish this main exercise.
please,
If the PL was to be dismissed,
please,
then we'll examine this. Then in any case, you
lords,
may
only,
succeed.
only indulgence is this, my lords. In this writ petition, the interim order, my lords, was that we can go ahead with the recruitment process, but not notify.
In the final stage, if this matter
Lords,
was
we
to be
have-
deferred,
But all
then we
the,
can understand giving you a further interim order or modification of the interim order. But we are completed to hearing other, we are at the rejoinder stage.
lords, I get it, my lords, but only thing was this, my lords have allowed similar notifications of the same timeline.
Right, but we were not hearing the matter. The matter was pushed. Your statement was that now the transfer petitions are being filed and the Supreme Court, this matter will never be heard here. So we have to protect some interim orders now, and we are at the final stage. We are in the middle of the hearing.
Please.
More than middle of the hearing.
But it's almost at the fag end.
It will be a fag end. Now, where is the question of granting interim orders?
Please.
We'll give you a final order one way or the other.
I represent respondent 5 to 8, my lord, in the impleading application which I filed in WP serial number 6, my lord, 200448 of 2025, my lord. And I adopt the arguments of the last senior counsel. But for one point for consideration, my lord, your lordship may kindly take the amended petition filed in WP 25515 of 26, my lord. In that page 162, annexure J is being relied on by the petitioners.
Which
petition? 25515 of 26, my lord. Amended petition filed, my lord, is on 28/7/2026, my lord. In that, my lord, your lordship may kindly come to annexure H, page 156, my lord.
Yes.
My lord, your lordship may kindly come to page 162, my lord. This is reservation of scheduled caste and scheduled tribe in the state civil services. My lord, your lordship may page 162, para 4, my lord. Reliance is placed on this para by the senior counsel for the petitioners, my lord, stating that there is already an over-representation of scheduled caste up to 99,337, equivalent to 18.65%, my lord. Your lordship got it, my lord?
Yes.
Now, your lordship may kindly come to page 163, my lord. Para 9, my lord. May I read, my lord? The report itself says that the data may not be, my lord, accurate, and therefore, my lord, in the last two lines, in this context, difference may be observed between the figures of the previous year and this year.
Which page do you want us to see?
Page 163, para 9,
Yes.
my lord.
Yes.
Now, the limitations of the data collection.
Yes.
Now, when the departments provided the data for this report, there is possibility that the information regarding those serving on deputation from some parent department to other departments may have been included or omitted. Furthermore, it is possible that the government may have authorized special recruitment for education, administration, and health and family welfare departments. Excluding these departments, there may be instances where new posts were created in other departments due to the implementation of the newly centralized sponsor scheme, or some sanctioned posts may have been abolished after the completion of the tenure of an existing scheme. In this context, differences may be observed between the figures of the previous and this year.
Yes.
What I'm trying to bring to your lordship notice is that the report of at annexure H may not be, my lord, relied on for the reason that, my lord, the very data that is collected is, my lord, doubtful by the report itself. And in fact, my lord, in the Nagmohan Das committee's report, my lord, at page the Lordship will get it, the exact version, my lord, is at table 8.15A, my lord. That is internal page 215.
Yes.
Not table 8.15. Lord, your lordship will get it at for 2018, my lord. The number of SCs filled the post is 85,427, which is equivalent to, my lord, 11.15%.
Yeah.
Considering the proportionate increase, my lord, it would be less than, my lord, 15% as on the date, my lord, that is 2023 when the act was framed.
No.
Therefore, my lord, there's the annexure H may not be relied on by, my lord, for
No.
considering that there is adequate representation. That's all.
I am only for the interveners, perhaps, who are the successful candidates in the KPSC exams, perhaps, where gazetted probationers exam. Now, now your lordships have been hearing on the merits of the matter, where is it 50 or 56%? Ultimately, it is this much. So, not getting into the merits. What I'm just pointing out, in this debate, the successful 50% of the candidates who have tendered their exam, they're successful. They should not be allowed to suffer in any form, because it is not, the courts are not powerless, directing the authorities to segregate or make a separate bucket of these 6% of candidates. And these separate 6% of candidates, subject to whatever dispute, because it may end here or it may never end here. That is the volume of this and the girth of the dispute. Hence, if the 50% is bifurcated.
No, that is the interim order already granted in some cases.
No, my lord, the interim order
was granted to that extent, in the other cases.
Clauses, but you can go ahead with recoupments with giving with a caveat to the persons that you do so, it will be subject to the outcome of.
And that is not the order which is followed in KPSC. And there is one more case, I think the BBMP matter, where that was by direct exam. That does not have a 3-tier exam, but only a 1-tier exam, where on a written examination, certain candidates have been.
I think we'll finish on. I think we'll finish the merits of it.
Lord, I appear for some of the intervening applicants, my lord.
Yes.
If that direction is issued, to the authorities, I think it will subserve and put an end to major list which is there before this.
Yes.
I appear for some of the intervening applicants whose applications have been allowed by the earlier division bench, and we have filed the written arguments on behalf of the intervening applicants. We are all general merit candidates supporting the applicant before the Karnataka State Administrative Tribunal, and supporting the order of the tribunal to the extent that on 2 grounds the tribunal has allowed the application. One referring to the judgment of the apex court holding that beyond 50% reservation as a matter of the legal position as it stands is bad in law. One. Secondly, another important aspect which is uncontrovertible, and from the reading of the judgment by learned AAG, exactly stopped at the places where judgment has to be read. For example, Rashid may take the WP number 18,295 of 25, my lord, filed by the state, my lord. In that, kindly come to judgment of the tribunal, which at page 67, my learned senior advocate and AAG stopped at 13, saying, para 13, my lord, before going to the merits of the order and issues claims under it is pertinent to examine the factual position and date of various notification, particularly ordinance and all. Para 14, he read, but at that stage stopped. Kindly, what has been reflected in para 14 is very important, because the act itself, that may not, in this order before the tribunal, rightly the act was not challenged, because act did not on its own come into force. Act contemplated certain rules to be made and thereafter to implement it. For that, your lordship may kindly see page number 68, kindly rules, section 7 of the act itself, my lord. Even without challenging the act, the issue of a government order is unconstitutional, illegal, because there is a certain act to be performed under the act. Section 7 says, if any my lord, 6, my lord, I'm sorry, 6, page number 69, power to make rules, my lord, power to make rules. The government may by notification in the official gazette can make rules for carrying out the provisions of this act. So once the act comes into force to enhance the reservation under the act, which itself is subject matter of challenge, let us say act is valid. Then what is to be done is important. Act says the government may by notification in the official gazette make rules for carrying out the provisions of the act. So the next action, they say that we issued a government roster in 2022 and therefore we are going to proceed recruitment. That is impermissible even according to their own rule act, because act contemplates under section 6 to make rules. Every rule, not only making the rule, how it should be made, Miller. A rule made under this act shall be laid before each of the House of State of Legislature while it is in session for a total period of 30 days, which may be comprised in one session or two sessions. And if before expiry of session so and so, may not have power, then this is under the act to implement the excess reservation which they are making, they have to make rules. Till date, no rules have been made under the act. Yeah, instead of making rules, they were in such a hurry to make recruitment, they issued the KPSC notification on the basis of act itself and the so-called government order of 22. Then one more aspect has to be taken note of, one more event. These two are very important aspects. Learned EAG, for whatever reason, did not read. Page number 70, second paragraph, page number 70. After extracting the rules, tribunal said, in view of the chronology of events, government order clear government notification of 28/12/22 notifying the roster points is based on the ordinance notified on 22. Subsequent to the act by Karnataka legislature, its notification, no rules, no notification has been issued by government as learned people have not produced. Not only not produced, it is not there. Not
All right. All right.
and one more thing, one more last thing, Lord. This very government order of 22 on the basis of which KPSC issued notification has already been quashed by the tribunal in the earlier proceedings, which your lordship will find at page number. That earlier proceedings, my lord, kindly see. Tribunal has already page number 75, para 16, my lord. Page number 75.
See, we'll examine all of this question and is at a later stage. It's not here at this point. Who's appearing for the petitioners now?
Let's say appear for the petitioner.
I appear for the, but I appear for the intervener in Lord in 6.2, Lord. May I seek your lordship intervention to have it on Tuesday, Lord? I will not take more than Lord 45 minutes.
6.2 intervention. We are not hearing you on 6.2 or 6.4. Anyone in 6.3 has to be. We have to continue on 6.4. That is against that order. We have not allowed them to complete the whole argument. There is a question of allowing an intervener in this. We've asked them to hold their arguments till this decision is decided. So where is the question of allowing an intervention in their application?
I appear in 6.2 state. I'll depending on the outcome.
Depending on the outcome, we'll examine.
Yes,
Please may advance submission depending on the outcome.
Lords, if I may seek time for the reply, my lords. Lords may have it tomorrow or whenever.
No, we'll give you not tomorrow. Not even next week, but thereafter we can give.
Will not take more than 20 minutes, my lords.
Mr. Verma also wanted 20 minutes.
The petitioners, my lords, possibly.
27.
My intervention application is rejected, my lord, then. So I will have no opportunity. So there is an application, my lord, pending. If you reject, my lord, I will have no opportunity.
Yes.
In 6.2, my lord. In 6.2, intervention application is pending. My lord said, Lord, you can argue the case.
When the case is argued, we'll consider whether your application is to be entertained or not.
Yes, Lord. Tuesday, I will not take more time. I will.
No. What up, sir? Date in control?
27/8, sir.
Okay, thank you.